Okay, let's just dive right into this explainer. If you've just been appointed as a company secretary, well, first of all, congratulations. But also, take a deep breath. You're now the ultimate guardian of corporate compliance, and we've put together an essential survival checklist just for you. Look, you might be staring at a massive, completely overwhelming legal rulebook right now. Let's be real, the Articles of Association can look like some ancient, undecipherable text where you're just one paper cut away from a lawsuit. But don't panic. We are going to break down exactly what you need to extract from those documents so you can take absolute charge of your very first board meeting. We're turning all that heavy legalese into your practical, day-to-day operational guide. So here's our game plan. We'll cover 1. Pre-meeting prep, 2. Managing quorum and chairs, 3. Voting mechanics, 4. Board dynamics, 5. Money and dividends, and finally, 6. Legal executions and indemnity.
All right, kicking things off with Section 1, Pre-Meeting Preparation Essentials.
So, your actual job begins way before the gavel ever drops. It starts with setting boundaries and controlling access to information. Now, here is a crucial point. Members cannot just barge into your office and demand to see the books. No way. As the secretary, you have to enforce the specific limitations set by the board or by law. It's totally up to the board to determine whether, when, and exactly under what conditions those accounts are open for inspection. Basically, you are the gatekeeper. A polite no is completely legally backed, unless access has been explicitly conferred by law or by the board itself.
Okay, moving on to proxies. You've got to be absolutely meticulous here. First, verify the proxy uses the exact prescribed form under Section 105. And keep an eagle eye on the clock. They have to be deposited at the registered office at least 48 hours before a general meeting, or if it's specifically for a poll, at least 24 hours beforehand. And here's a wild little detail. Proxies actually remain valid even if the principal dies or goes insane, provided you didn't receive written notice of that before the meeting started. Honestly, timestamping everything is going to be your best friend.
Now, keep in mind that the founding subscribers of the memorandum are the ones who initially determine the board's numbers and the first directors. But moving forward, your duty is super proactive. You literally must summon a board meeting anytime a single director formally requests one. You're the engine keeping this executive machinery running. And part of that means maintaining the official attendance books and making absolutely sure every single director signs their name when they walk in the door. Moving right along to Section 2. Managing quorum and chairpersons.
All right, it's meeting day, and obviously, no business gets done without a legal quorum. But what actually happens when key players just don't show up? Well, the clock is ticking. If the official chairperson is a no-show, or if they're unwilling to act after exactly 15 minutes from the scheduled start time, there is a precise sequence to save the meeting. At minute 16, the directors who actually are present just elect one of their own to take the chair. No directors around? Then at minute 17, the members present choose one of themselves. As the secretary, you've got to watch that clock like a hawk, ready to advise the room the literal second that 15-minute mark hits. Next up, Section 3, Voting Mechanics and Resolutions. Let's dig into the nitty-gritty of voting rights. It can get messy, right? Especially with joint shareholders. Like, who actually gets to cast the ballot? Well, the articles are crystal clear on this. Seniority wins, period. Whether they're voting in person, by proxy, or electronically, which, by the way, strictly allows only one vote per member. Seniority on your official register is the ultimate tiebreaker. You only accept the vote from the first name listed on the register, completely excluding the other joint holders. So, what happens when tensions run high? Imagine someone suddenly objects to a voter's qualification right in the middle of a poll. The room erupts. What is your immediate protocol? Actually, your role here is to totally step back from the argument. You smoothly route any objections made in due time directly to the chairperson. The articles state that any vote not disallowed right then and there is valid for all purposes. By punting the dispute straight to the chair, whose decision is legally final and conclusive, you shut down the debate instantly. You don't argue, you just route. I do want to quickly point out how dramatically different this is if you're managing a one-person company, or an OPC. You get to completely bypass the quorum, the show of hands, the polling, the whole shebang. The resolution becomes 100% effective the very second that sole member or director agrees to it, signs it, and dates it in the minute book. It is a massive administrative shortcut. You just have to make sure you log it correctly. Okay, Section 4, Board Dynamics and Appointments. So the board isn't just a static entity. They actually have the power to delegate their authority to specifically formed subcommittees, as long as those committees strictly follow whatever regulations the board imposes.
On top of that, the board can appoint additional directors at any time, up to the maximum fixed strength allowed by the articles. But there's a catch. These additional directors only hold office until the next annual general meeting. By keeping track of these subcommittees and temporary appointments, you're the one helping the board maintain continuous, agile leadership.
Let's talk about the money. Section 5, Managing Money and Dividends. As secretary, you're overseeing the flow of executive funds, making sure every single penny follows strict legal protocols. To keep the directors happy and completely compliant, you have to calculate their monthly remuneration as accruing on a day-to-day basis. Plus, you'll be processing all those travel and hotel claims. The big test here? Making absolutely sure those expenses were genuinely incurred for attending board or general meetings or for conducting general company business. No free vacations.
And when it comes time to share profits with members, there is a very specific legal flow. Step 1, the board recommends a specific dividend amount based on profits. Step 2, the general meeting declares it, but they can never, ever declare an amount higher than the board's recommendation. Now look at step 3. This is you. Your administrative duty is to intercept and deduct any unpaid calls or debts owed by the member to the company before you apportion and pay those proportionate dividends. You are literally the final filter. Finally, we're at Section 6, Legal Executions and Indemnity. This is the administrative closure of your checklist. The company seal? Yeah, that is not just some rubber stamp you casually leave sitting on your desk. The board has to provide for its safe custody, and the procedure for affixing it is entirely non-negotiable. First, you have to get a resolution from the board or an authorized committee. Second, you ensure at least 2 directors are physically present. And third, your co-signature as the secretary, right alongside those 2 directors, is legally required to finalize the execution. It's a big deal. Part of the gig is also preparing for the absolute worst-case scenarios. Even in the extreme event of a company winding up, you've got a job to do. You have to facilitate the special resolution that allows the liquidator to fairly distribute physical assets, in specie or kind, among the members, based on a fair value determination. But hey, after all these massive responsibilities, here is your ultimate safety net. The articles actually state that every officer of the company shall be indemnified out of the company's assets. Basically, if you or the directors act properly and you're ultimately acquitted or granted relief in any civil or criminal proceedings, the company covers your legal liabilities. It's there to empower you to act decisively and correctly, knowing the company has your back. And that brings us to the end of the checklist. Armed with this explainer, you're not just sitting in the background keeping notes anymore. You are the indispensable guardian of corporate compliance, the literal legal backbone of the company. So, if an objection erupts during a poll tomorrow, or someone demands the seal without a resolution, are you ready to be the smartest legal mind in the room? Thanks for joining me on this explainer, and we'll see you next time.